Welcome to the Stratford IP Strategy Academy. In this session, we discuss a common mistake when it comes to IP and employee agreements, and what happens if there's an error or omission in the inventor declarations of patent applications. You can mitigate issues relating to IP assignments if you have proper employment agreements in place before formal IP protection is sought. Let's get started. It's not uncommon to discover that one or more of your patent applications may be missing important signatures. Sometimes it can easily be overlooked if there's a pressing deadline, or it's caught later during due diligence. In some cases, it could even be a simple misspelling of one of the inventor's names. Whatever the reason for the missing signature, it's a myth to think that once a patent application has been filed and assigned to the company, the inventor's signatures are no longer needed. It's also a myth to think that an inventor can be removed from a patent application if they were to leave the company or become uncooperative before the patent issues. Proper documentation, including the names and signatures of all inventors, is imperative to the enforceability and value of your patent. So, it's important that you're taking the appropriate steps and using the correct language in legal documents to ensure that there is no doubt when it comes to the assignments of your IP rights. To avoid issues and uncomfortable scenarios with disgruntled former employees, it's important to include contracts and agreement clauses relating to IP from the very beginning of any business relationship. We've seen it happen where companies that are founded between trusted partners often overlook creating agreements for things like IP assignments. If the founder was involved in filing patent applications, this opens you up to the risk of having to abandon assets should they leave in an acrimonious manner. There are a number of common scenarios that you may encounter which could cause issues with ownership or transfer of IP assets. An employee has since left the company and can no longer be found or contacted. If they have, unfortunately, passed away, or if, as mentioned, they simply refuse to sign. Another instance that you should be aware of is if you hire students or sponsor graduate studies. Some of the work produced may be considered property of the university. Therefore, it's key to check the university's licensing rules and negotiate an assignment prior to engaging with the student. It may be necessary to file any relevant thesis produced by the student with the patent office in an information disclosure statement. Most employment and contractor agreement templates include an IP assignment clause. It's important to note that if someone refuses to sign any IP-related documents in the future, the contractual clauses should be worded such that they can be used in the patent office in lieu of the signature to prove that you have the right to own the invention and will not have to abandon the invention or the investment. There are many other important components relating to IP to cover in an employment agreement, including strong NDAs related to trade secrets. Simple employment templates found on the web may not provide sufficient IP considerations. It's best to get the opinion of a lawyer or trained IP professional to ensure your rights are properly protected. It's also important to note that you have the legal obligation to include the names of all inventors on the patent application. This means that anyone that was directly involved in the conception of the invention must be named. For continuing applications, you must include all the original inventors, even if they have not contributed to the amendments found in a new application. If you remove an inventor for any reason other than a legitimate mistake, you run the risk of invalidating the patent if it can be proven that the inventor was omitted from the documentation. IP is a valuable asset, so it's important that your company rights are protected when it comes to IP ownership. To protect your investment and claim ownership, it's important that all contracts include language that covers IP appropriately. In the event that there are any issues down the road, these contracts can be used in lieu of inventor signatures to prove your ownership with the patent office. Should a dispute arise, remember that inventor names must remain on the patent application regardless of their status within the company.